The Coney County Council. I'd like to call this meeting to order. We will begin as usual with our public comment session. Mr. Tony Adams.
I'm speaking on behalf of Fair Oak Youth Center in reference to our lease for the old Oakway Intermediate School with the county. The officers and board of directors of Fair Oak Youth Center need some clarification from the council on your expectation concerning Fair Oak Youth Center's negotiation and execution of subleases at the old Oakway Intermediate School. On December 6th, I received the following email from Mr. Root. It has come to my attention that Fair Oak Youth Center either has leased or is in the process of leasing portions of the center under subleases that have not been approved by county council. If that is the case, please forward to me all such proposed leases and any that have been entered into as soon as possible. Many thanks. 3 signed subleases were delivered to Mr. Root on December the 7th. Mr. Root's email was discussed at Fair Oak Youth Center's monthly board of directors meeting on December the 12th. Needless to say, Fair Oak Youth Center was under the impression that county council was fully aware of our subleases. To highlight this, let me digress back to September the 8th of this year when I sent Mr. Root the following email. You probably got 2 copies of the subleases. They are both the same. I could not tell if the first one went through or not. To which Mr. Root replied, "Got it, thanks. I forwarded it on for inclusion on September 19th, 2017 County Council meeting agenda as well." The following was part of the discussion regarding action items on the September 19th Council meeting agenda. Approval of forms of proposed subleases between 1, the Fair Oak Youth Center Incorporated and Upstate Children's Center of Oakway Incorporated, and the Oconee Conservatory of Fine Arts, the Upstate Heritage Quilt Trail, in relation to the former intermediate school, now owned by Oconee County and leased to the Fair Oak Youth Center. In early November this year, Julian Davis, District 4 Council member, asked Fair Oak Youth Center to update the Real Estate Facilities and Land Management Committee on Fair Oak Youth Center's activities at Oakway. An update on Fair Oak Youth Center was included on the November 14th, 2017 agenda for the Real Estate Facilities and Land Management Committee meeting. Mr. Davis and Ms. Kamick were present for this meeting, and Mr. McCall was absent. Mr. Kane and Mr. Hart were seated in the back of the council chambers. Terry Swain updated everyone on Fair Oak Youth Center's athletic programs, and I updated everyone on administrative activities of Fair Oak Youth Center. I went back and reviewed my speaking notes from this presentation, and I specifically mentioned Fair Oak Youth Center has 3 signed subleases and 2 more pending. So I could believe you can see why we were somewhat perplexed by Mr. Root's December 6th email that seemed to say he had just become aware of our subleases. Article 10 of our lease, assignment and subletting of Fair Oak Youth Center's lease, states that leasee may not sell, assign, sublease, convey, or transfer all or substantially all of the leasee's interest in this lease and the leasehold estate created hereby, without the prior written consent of leaseor, which consent shall not be unreasonably withheld or delayed. Our sublease with Upstate Children's Center of Oakway Incorporated is the only current sublease that even comes close to the above requirements, and the council approved this sublease on September the 19th, 2017. Since his December 6th email, Mr. Root has also expressed concerns about ensuring we are subleasing for permitted uses and our tenants meeting insurance requirements. We believe we have answered these concerns with the 3 subleases he has copies of. Mr. Root also mentioned that the county was leasing Fair Oak Youth Center to the Oakway property at below market rates and had to ensure the best interests of the county were being met. We were told that the only other option on the table for the Oakway Intermediate School building was a wrecking ball and a rubble pile on the back 16-acre field. Is that the market rate Mr. Root referred to? Fair Youth Center is asking to be allowed to negotiate and sign our subleases without having to delay the process by getting prior approval. If you take Mr. Root's December the 6th email at face value, the entire council has to approve each sublease. Mr. Root did concede that full council approval may not be required, but that the administrator thought he needed to approve all subleases to ensure the best interests of the county are being met. All of Fair Oak Youth Center's officers and board members are residents of southern Oconee County. And I believe we're better prepared than anybody to determine what's in the best interest of the communities down there, or as prepared as anybody. Fair Oak Youth Center will be glad to furnish the county copies of any executed subleases, which are basically carbon copies of the forms already approved by full council. We will also provide any other pertinent information required by the county. Fair Oak Youth Center has made good progress at Oakway since our lease was signed off August 8th, and we don't want anything to impede future progress. I have heard 2 council members comment in these meetings about it taking so long and being so hard to do business with the county. This is an opportunity for you to put your words into action. I believe we all know which speaks louder. I plan on leaving after my comments to attend Upstate Children's Center of Oakway's open house tonight. However, if you anticipate questions later on, I'll be glad to stay. Thank you for your time.
Thank you, Mr. Adams. Mr. Markovich.
Thank you. For the record, I'm Tom Markovich, and I wanted to speak on the first reading of the ordinance 2017-33, which has to do with the overlay and silt fences. First, let me make absolutely clear I'm totally in favor of having strong silt fence language. This is something that I do on my projects, whether I'm on the lake or not. We automatically silt fence because we're going to be grading. We don't want runoff going anywhere. That's just how we operate. And I think most of the responsible contractors in this county operate the same way. Now, however, and there was a lot of discussion at Planning Commission about how to get this thing structured, and I realize it's not a real easy thing to do because there's not a lot of guidance from the state. If you were to do a search and try and find silt fences anywhere in the state code, you're not going to find it. Doesn't exist. Go into the regulations, you're not going to find it. Doesn't exist. The only place where you're going to see silt fences show up is South Carolina DOT. But that's a whole different issue. Now, I basically like what's here except Mr. Root always accuses me of having a butt. Well, Mr. Root, I got a butt. In the last section of this ordinance under penalties, it talks about some of the things that can be done, and one of them is revoking a building or a zoning permit. I have issues with the idea of revoking a permit because that means, let's just say somebody's got a permit on the lake and it's a house that's $750,000 house, that's a $3,000 permit. And if you revoke that permit, they're going to have to buy a new permit to be able to restart. I don't have issues with stop work orders. I don't have issues with suspensions while something is getting rectified. But to revoke is a pretty strong measure. And it's one that I'm not really sure, well, I'm pretty sure. The zoning administrator doesn't have that authority to revoke that permit. And as you go back through, the only one who can actually revoke a building permit is your building codes official. Now, I don't know how you connect the two because this talks about referencing the property maintenance code. The property maintenance code and the building code are two entirely separate codes. They have two, even though if they may be the same person, they are different administrators. One administers one code, it could be the same person, but he can't represent both codes at the same time. And there is nothing in the property maintenance code about revoking permits. So all I'm asking is that we change that language on revoke and maybe make it suspend or some sort of thing like that. Thank you.
Thank you. Next is Mr. Tom,
Borilovitz.
say that again?
Borilovitz.
Gorilovitz.
Again, my name is Tom Borilovitz. I'm from Greenville, South Carolina, actually Simpsonville. Thank you for allowing me to speak tonight. I'm here to speak on the SC Jada $1.5 billion bond resolution, and I think that number still shocks everybody. I think it's like 15% of the entire bond issuance by SC Jada in the last 30 years in one fell swoop. It's quite incredible, and it commingles the debt from the troubled Palmetto health system and with a good healthy system like GHS. And we've got a great healthcare system up in the state. I think we got a great healthcare providers here, and we shouldn't be trying to commingle and merge those two systems together. I think unbiased healthcare experts have said all along, every time these hospitals merge, they use their silken words to say how much they're going to do for the community and how much they're going to do for the poor. When all that really happens is hospitals merge, they yield more pricing power against consumers via the insurance companies. And that's what happens over and over and over across the United States. I think even when I was at a GHS board meeting in 2015, one of the executives said that when the dust settles, there's going to be 20 super giant regional hospital systems across the United States, regional monopolistic hospital systems. That's it. And is that the plan? And that, I don't think that's good for consumers especially the poor. The poor are affected the most by these giant consolidations. They may say they provide all this poor help, but in the end, most people know that when prices go up, the poor are affected the most, and that just chases them out of the healthcare system altogether. So, but getting back to this whole resolution again, Palmetto Health took on the healthcare system in Sumter that was bankrupt, and it got convicted of Medicare fraud. I think I've sent you guys an email on that. We don't need to be part of that system. Let them derive and improve their own healthcare system on their own. And they keep saying the GHS officials and the SC Health Company keep saying that, well, we're going to derive all these savings out of it. How? When you got these healthcare systems spread out across half of South Carolina, and their plan is to make a huge system from North Carolina through the Midlands, down through Columbia, into the coast. I mean, that's what their stated plan is. And we're just sitting there going, how can this be good for the upstate? I don't think bigger is better. And they say they're going to save I think they told you guys in the last meeting, $60 million. And if you take $60 million over the 30-year bond period, you divide 30 into 60, that's $2 million a year, divided by the approximately 1 million customers that GHS and Palmetto combined will be serving. That's about $2 per person per year. That's the price of a candy bar. And they say this is so important to get done, and they may even claim they're going to have all these savings per year by the merge. And where are the savings coming from? The $100 million or whatever they say they're going to save through cost reductions. I've done a lot of research and looked at what the analysts have said, and these savings never are realized. They may spend more down, let's say at Palmetto, but in the end, what happens is the savings aren't there. Healthcare quality goes down because a centrally planned healthcare system is what it is. How can it provide and know what's going on the local level when it's centrally planned? So I just encourage you to not vote for this bond resolution because it commingles Palmetto health system and a good, healthy GHS debt. If we want to refinance our debt up here in Greenville, South Carolina, let's do that and get a better rate. That's what should happen. We have this lawsuit. I'm just a taxpayer. I'm not paid lobbyist. I don't work for some giant corporation. I'm just concerned to see what's going on. That's all I'm doing. And I've studied this for 2.5 years. And I've read so much about healthcare across the United States, what's going on. And I see like in New York, in New York City, 2 hospitals merge. They go from one, they have a CEO and they split the position up to 2 positions. He was the president CEO. When they hired another, when he left, 2 guys took those 2 positions, more than double the rate. So, this is what we're looking at. Are those savings going to come to this county? I highly doubt it. One of the other things is to keep in mind is, we talk about the EMS service up here in Oconee. I know some people were talking about trying to get better service, the EMS service up here. And, I just saw on the news recently, I just read an article here. Cherokee County, the hospital system in Cherokee County who's running the EMS just said they're going to drop it. They can't afford it. And I looked at the bottom here. It says Cherokee County Administrator Holland Ballou referenced a 1984 contract that obligates the owner of the hospital to provide EMS to the county. They're just dropping it out of a whim. Now the county's struggling, and this is what happens when you turn everything over to one entity, like that. So the consumers are kind of left without anything. They may say they're going to save money, but in the end, taxpayers, your citizens that you represent, are going to see those prices go up. It may not be in the tax bill, but it will be in reduced service or higher costs, and probably both. So thank you very much, and I again urge you to vote against this resolution. Let our lawsuit proceed, because we think that they violated Act 432, and we think that we have a great case, and we're going to win it, and we're going to bring the hospital system back to the taxpayers of the upstate. Thank you.
Thank you. Council member comments. Mr. Jim Carpenter.
Thank you very much. I'm Jim Carpenter. I'm the lawyer representing the plaintiffs in the suit against Greenville Hospital System. And what we see in this $1.5 billion bond issue is an attempt to make the legal issues in our case moot. We believe that if you take the bonds of 4 different hospitals and you scramble them all together and you allocate liability across the board, regardless of the source of the debt and regardless of the purpose of the debt, then I think you scramble the assets so much that even if we win on the law, even if we prove, and I think we will, that what they're doing is illegal, they will say, well, it's too late. We're too far down the road. You can't unscramble the egg. We've encumbered ourselves with all this $1.5 billion in debt that belonged to other people, and we're all scrambled together now, and it's just too late to go back to undo all the wrongs that have been done, and we just have to go forward with it regardless of whether it was right or wrong. And that, as a person and a citizen, a taxpayer, that rubs me the wrong way. That offends my sense of right and wrong, my sense of morality. We have 5 principal causes of action in our case, and I don't know if you all are interested in what we're alleging, but I'd like to cover them very briefly for you. Act 432 was enacted by the General Assembly back in the 40s, which created the Greenville Hospital System. And one of the things Act 432 said is that the hospital system must be governed by a board appointed according to this section. And that act has been amended many times over the years. The legislature has been very responsive to GHS when they've come to them and said, we need this change or that change. But one of the provisions that's been in that act consistently from day one to the day we're sitting here is that the hospital must be governed by a board appointed according to Act 432. With this reorganization, they have taken all the power, all the governing authority, all the control away from that board and given it to another board, a private board, a self-selecting, self-perpetuating board accountable to nobody, least of all to the legislature, which appoints the board according to Act 432. It is a huge violation of Act 432, which is currently still a controlling statute on the books of South Carolina. So that's our first cause of action, that it violates Act 432 to turn all the governance of the hospital over to a private, self-selecting, self-perpetuating board accountable to nobody. We think that under the common law of South Carolina, the board's only purpose was to govern the hospital. And when they give away to somebody else their only function, that is trying to delegate a duty that can't be delegated. It's their duty. In other words, the police force can't go out and hire security guards to be the police force while they all, sit in the park or whatever. Their job is to do the police force. So this board's only job is to govern the hospital. And when they give away their only job, that is delegating a non-delegable duty. The third cause of action we have is that it's a violation of their fiduciary duty. Boards governing a hospital have fiduciary duties. A fiduciary duty is a duty that's owed to someone with a special relationship. If you are a trustee or guardian for an older relative, or where you act in their best interest, that's a fiduciary duty where you use the utmost care. These board members, South Carolina courts have held, are fiduciaries. They have a fiduciary responsibility to the hospital and to the people that run the hospital. So they are violating their fiduciary duty by giving it away to this private, self-perpetuating board. Another law is that a board like this county council cannot bind future county councils. And with this deal that they've gotten into, the hospital board purports to bind future hospital boards for the next 100 years. They took all the discretion, all the decision-making authority, all the control away from future boards appointed according to the section, Act 432. They've taken it away from them by signing this 100-year lease, giving away all their assets. And finally, our fifth cause of action is the idea that these two organizations, the SCO, which makes all the decisions for the hospital, and the UAO, which runs the day-to-day operations, they contend that they are not subject to the same restrictions that the board appointed for Act 432 is subject to. They contend they have more freedom, they have more power, they have fewer restrictions than the board appointed according to Act 432. But as I understand the law, they were appointed by this board. They were created by this board. And a board cannot create another organization that has fewer restrictions or more power than the one creating it. They're the agent, and the board is the principal. The agent can have no more authority than the principal. You can't hire somebody and pay him and say, all right, I want you to speed down Main Street at 80 miles an hour. And because he's your agent, he can go down there and speed 80 miles an hour down Main Street. He can't do that any more than you can. But this board, by entering into this agreement, attempted to make these organizations with fewer restrictions and more power than the board itself, and that's just against the law. So those are the first five causes of action. I'd be happy to address any questions you have about the nature of our lawsuit. It is still in process. We don't have a ruling on it yet. We're going through the discovery process. I sat through a long, boring deposition today in that case. But we are pursuing the lawsuit. We believe we're right on the law and that ultimately we will prevail. But if this scrambling of $1.5 billion in bonds goes forward, we could get a ruling down the road and it might not mean anything, even if it comes from the circuit court. So we ask you to vote against that and not approve such a scrambling of the assets until the court has ruled on the legal issues which are pending in our case. Thank you very much.
Thank you, Mr. Carpenter. Okay, now, any council member comments? Nope. Mr. Root, regarding Mr. Adams' comment, I thought we had previously discussed that we would take a look at those subleases, make sure we're okay with them and let them, lead the way on that. So what has changed?
I don't know that anything has changed in regard to that. The really three primary provisions within, we'll call it the master lease now at this point. This is a lease between the county and the Fairhope Youth Center. Requires one that if substantially all of the leased premises are going to be subleased to somebody, that you have to approve it. So for us to know how much is going to be subleased, whether it amounts to substantially all, we need to know if something is being subleased. So the administrator at least needs to review that.
Okay.
And then if it's a substantial portion, then it needs to go to you all. A second provision is that the sublease needs to be consistent with the lease as to permitted uses. And when Mr. Adams spoke about community benefit, he's talking about, my reference was to the public purpose rule. We're leasing the property at really nominal to no consideration to the Fair Youth Center, and in fact giving them some extra money to help facilitate the early stages of their enterprise. For us to be able to do that as a county, it has to be for a public purpose. So we need to know what the subleases are for. Are they consistent with that public purpose, which is community enrichment, those type of facilities? So if there's a fireworks stand or something like that they're subleasing, we need to know about it. Or perhaps a landscaper, which is on the agenda this evening for their second lease. But that is something that y'all need to be able to review. The third portion is to make sure that they have their insurance requirements with their subleases up to date. So we're covered as we're required to be covered in the sublease. So nothing has changed, but we need to see those subleases. And when I heard that perhaps there was one out there that I didn't know anything about, then we started the ball moving, found out that there was indeed one that I didn't know about, and perhaps more, which turned out to be the case. That's when I wrote the initial email and said, "Oh, let's find out about these. Council may need to approve them," and we have 2 of them for approval now. I understand Mr. Adams wanted to move with some alacrity, but at the same point, we have some checks that we just have to do.
Okay, very good. Anything else? Okay, on that note, please join me for a moment of silence. Thank you. Mr. Root?
Pray with me if you would. Father, first of all, just thank you for creating us and giving us this day, a day made for your glory, for our good. Hearts. At this season, this time of year, we kind of wrap business up. Help us to reflect on the opportunities you've given us and the things that we've been able to accomplish, to be grateful for those, not to be proud in a wrong way, but to be humble and appreciative of the good that we've done, that council's been able to effect, and from the things that we've learned, perhaps from mistakes, failures, that we'll fight for those lessons too. Pray, Lord, that we go, as we go into this season, that we have hearts that are soft and open, your love to our neighbors, not even as we do this.
Thank you. Mr. Davis, the pledge.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We have a special presentation tonight by Ms. Emily Roberts of Duke Energy. Thank you for coming.
Thank you, Madam Chair. Other council members, thank you for having us here this evening. I'm here with my esteemed colleagues, Mr. Ed Birchfield, who is the new Site Vice President at Oconee Nuclear Station, and Chris Reimel, who is the South Carolina Communications Manager from the World of Energy. We are here this evening to tell you that Duke Energy is here to stay in Oconee County. Duke Energy has been a vital part of the Oconee County community since the early 1960s, and we plan to be here for many years to come and to provide energy for our existing customers and the growth that is coming in the future. Our presence in Oconee includes the vital asset not only of the nuclear station, but we also have hydro and pump storage facilities that can be operated independently of the nuclear station. We also have critical transmission infrastructure in the area that connects Duke Energy to not only the national grid, but to the other Duke Energy Carolinas service network. And we have a robust distribution network that serves 10,500 homes and businesses just in Oconee County. In addition to the nearly $30 million in annual property taxes that Duke Energy pays in Oconee County, we make contributions to the community through the United Way, Ripple of One, other nonprofit organizations, and hundreds, if not thousands, of volunteer hours contributed by employees of the nuclear plant and other Duke Energy facilities. Before you, you have the report that was prepared by Dr. Van Nessen of the South Carolina Darla-Moore School of Business, University of South Carolina, excuse me, it's hard for me to get that out being an orange girl. It was prepared for Duke Energy regarding the Power Forward, I know, it's funny, Power Forward effort that Duke Energy has recently announced, which is basically an investment in our infrastructure in South Carolina. And Duke Energy plans to spend at least $3 billion, billion with a B, to make our system more robust, to be more reliable, and provide better service to our customers. And so you can look in that report for yourself and see what the effects of Oconee County will be. And the estimate there, I believe, is on the order of $1.1 billion will be invested in Oconee County, create countless number of jobs, and so we are continuing to invest in Oconee County as a company. So with that, I will give my esteemed colleagues an opportunity to make some comments, but I do want to say that we applaud the efforts on the part of your Economic Development Director, Richard Blackwell, and the Oconee Economic Alliance to bring a diverse group of manufacturers and other businesses to the county so that we can all enjoy the growth. We all know that the key to a thriving economy is to have growth. And so we're ready for that growth, and we're ready to grow along with Oconee County. Y'all have any comments you want to add? We'll add Ed.
Thank you.
Thank you for the opportunity to say a few things. My name is Ed Birchfield. I'm the Site Vice President at Oconee Nuclear Station. Very much appreciate the opportunity to speak for a few minutes tonight. We've operated safely our nuclear plant for decades, and we intend to operate it safely for decades to come. We have a highly skilled group of professionals out at the plant. We have over 1,000 Duke employees that work out there. We really, really see the value of that plant and what it does, not only for the folks that work there, but for the community. And to give you some perspective in terms of Duke's investment in nuclear, just this year, our capital expenditures at the plant will be about $180 million in improvements to the plant. Every year, we're investing in the plant to ensure that we'll continue to run well and continue to serve this area of the upstate. I'd also offer to you, I've been working at the plant for over 20 years, and I'm very proud of the workforce out there and the professionalism and their dedication. It's a great place to work. It's a great place to live in Oconee County. And thank you for allowing us to be a partner here.
Thank you.
Thank you for the time. As Emily said, my name is Chris Reimel. I'm Communications Manager for Duke's Nuclear Fleet in South Carolina. Part of that job, I have the awesome responsibility of managing the World of Energy. The World of Energy in 2019 celebrates 50 years. Now, a lot of people don't know this, but in the upstate and in the Carolinas and the United States and the world, there is no other nuclear visitor center that has operated as long. It's unique. It's one in the world. So it celebrates a year after Oconee celebrates its 150th anniversary. So my point of this tonight is to tell you, in 2018, the World of Energy's programming is full of professors, historians, photographers, enthusiasts of local history to tell the story of the Golden Corner, because we are celebrating your sesquicentennial a year before we celebrate our 50th anniversary. Thank you.
Thank you. Thank you all for coming tonight. I really appreciate it.
Madam
Okay.
Chair, if I may.
Yes.
I would like to thank y'all for everything that you do for this county and its citizens and the taxpayers, and we appreciate all that y'all do. Y'all also draw in a lot of people that move here for Duke Power, and that retire here because they worked at Duke Power. And, my father being one of those, so it's a very big blessing. Thank you for what y'all do and continue to invest in Oconee County.
Any other comments?
Madam Chair. Yeah, I just want to echo the comments of gratitude for what y'all have done in Oconee County, and the awesome resources that you provide here. Lake Kiwi, Lake Jocassee, of course, Bag Creek, and all the outdoor recreation resources, the tourism benefit that we see from that. Certainly, we can thank Duke for that. And so, thank you for continuing to pay your tax bill as well. We wouldn't be the same without you, and we really, really do appreciate you. So, thank you. Here's to many years of continued success.
Anybody else? Okay, thank you very much. Mr. Mulder, your turn.
Thank you, Madam Chair. I'll briefly go over your agenda for this evening. We've got 4 public hearings and a number of items on the agenda, so most of which are matters that we've had on the agenda and dealt with over the last couple of meetings. So I'll just provide just a brief summary of those items. First of all, the 4 public hearings and the subsequent third and final readings of all 4 of these ordinances, 28, 29, 30, and 31. The first of which would approve a lease document or lease agreement with Foothills Farmstead as the lessee. This is property that adjoins the Oakway Community Center that we had heard discussions about earlier in the meeting. It is the acreage on the rear of that property. This lease would allow for the creation of a educational opportunity as well as a tourism opportunity, and also to preserve and recognize a heritage and create a replica farmstead for people to experience the historical elements of the county as the farmsteads used to be. Number 29 is the authorization to seek financing for equipment acquisition at the rock quarry. This would be in the amount of $6.5 million and change that would be used to purchase new equipment at the rock quarry. It would be a complete replacement of the entire crushing plant at that facility. As you know, the current structure dates back to the 1970s. Now, again, some of the crushing units and equipment have been replaced throughout the years, even as recent as 2012. But the structure itself dates back to the original years. Mr. Martin, I believe, is with us this evening as well, in case there's any more detailed questions about the plan itself. But this ordinance would allow the seeking of the financing to purchase the equipment. Any purchasing, obviously, would still have to come back to council after a bidding procedure as well. So there's still a couple more steps to go in the process. Number 30 is the amendment to a fee agreement for iTech South, which was dated April 1st, 2015. This is purely an administrative adjustment. There's no extension or adjustments to the fee. We are including individuals associated with that organization as sponsors on the fee agreement based on their request. Number 31, this is an amendment to Chapter 38 of our Code of Ordinances, specifically related to the setback language for multifamily housing. As I try to describe, as you know, a duplex shares 2 residences will share 1 wall. Those 2 residences will be owned by 2 different individuals, therefore 2 separate parcels, if you will. And our setbacks require a minimum setback between parcels. A duplex has an adjoined wall, so this is merely a cleaning up to allow for multifamily dwellings to have a 0 lot line between those shared walls. The setbacks will still remain on the exterior walls of the property. It's just those interior shared will be adjusted. Again, third reading for those 4 items, no second readings. Ordinances 2017-32 is up for first reading tonight. This is the one that I jumped the gun on and tried to explain last week. This is a lease agreement with Mr. Kent Crooks for property that we own that borders the C&D landfill. It's 207 Crooks Road. This is a property that we acquired through a life estate purchase that was agreed upon a number of years ago. Unfortunately, the 2 elderly individuals passed away, and their siblings inherited the property. As soon as those 2 owners passed away, it reverted to the county as part of that life estate agreement. And the siblings had asked for a year to rent the property so that they could still take care of their family's affairs. We have did not at that point in time have any immediate need, and we still don't have any immediate need for that house. We would just board it up or tear it down at this point. I don't see any reason why we couldn't extend and renew that one-year lease with the family to continue using the property. They are paying rent. It's a triple net. They are required to carry all the costs associated with it. So they're asking for a one-year extension on that agreement. So I'd like to recommend you take that into consideration at this point in time. 2017-33. This is an amendment to the Chapter 38 of our ordinances, specifically as it relates to the Lake Overlay District. You heard some discussion on that earlier. It would be, the amendment would allow for some more teeth, if you will, for us to enforce certain sediment and erosion control issues within the Lake Overlay, and require some additional provisions, as well as provide some enforcement capability so we can actually require developers and or builders or homeowners, if you will, to comply with sediment control measures within the Lake Overlay. We've had a couple of issues lately where we've had some sediment runoff into the lake. We have included DHEC in those discussions, but unfortunately it's such a small amount or a small parcel, DHEC doesn't get involved in those. So we'd like to recommend that we provide some additional enforcement and a little more strength for us to enforce the runoff quality as properties are developed on the lake. Number 34, this is an extension of a fee agreement with Project Bremen. Project Bremen is an existing company that located here back in 2013. This extension would be for another 5 years, as they hope to invest another $3.8 million into that facility on top of what they had already invested up to this point, which actually exceeded the minimum requirement that they had at that point in time. We're proud to say. It will be a 5-year extension and include a 25% SSRC. Following resolutions, only one up for your consideration this evening, number 13. This matter was tabled from a previous meeting. This is, again, we heard discussion on. Resolution would provide the approval for the GHS and Palmetto Health under their combined South Carolina Health Company to seek JETA bonds in the amount of $1.5 million. Again, this is a requirement under the JETA authority that the hosting county of the facilities where the capital investment would be made or was made must approve a resolution to incorporate the debt associated with that host county into the scrambled pot, as we heard earlier today. Discussion regarding action items, the first of which is merely a letter of support for a JAG court system efficiency grant application. We're submitting a grant in order to make some courtroom and safety improvements at the courthouse. You see a copy of that letter in there, kind of describing how much and what we would like to do. But we're seeking that grant. Ms. DeRitter has been working with the Sheriff's Office as well as Ms. Kim Wilbanks on 2 grants to benefit the Sheriff's Department. The first of which is ready. The next one we hope to have ready for the first meeting in January as part of your business meeting. But there, again, the letter of support was in the backup for that. Typically, under the law enforcement granting agencies like JAG, they require the governing body to issue approval to submit the grant, and we've done that in the past before. Next item is the passive landfill gas vent trench bid. This is a continuation of the remediation at the closed MSW landfill. There will be continued approvals for County Council to consider for this big project. There are a number of different items that go as part of that. You can see the amount is $132,211 to dig this gas vent trench. Basically, it's a capturing device for methane, and it trenches and moves it along through the trench so it can be handled and it doesn't build up in the air. But the bid would be to Regenesis Bioremediation Products Incorporated for those remediation services and the vent trench. You have in your backup all the different bidders, the low bid, and the number of packets that were sent out. I believe it was 28, 25 plus packets that were sent out to companies. Total award would be $132,211 and approve any change orders within that amount. The next item was a review and approval of subleases. There's 2 of them for the Oakway Community Center, the Fair Oak Youth Center and Lifeline Community Church, and the Fair Oak Youth Center and Hyatt Landworks Landscaping. Board and commission appointments. I think I got word that somebody may have somebody, so that's good for at least one of them. And then no unfinished, no new. We do have an executive session items, 2 of them, as a matter of fact. One, to discuss the response from the Oconee Joint Regional Sewer Authority and receive information from our attorney regarding that contractual matter, and then to discuss employment matters related to evaluations and related forms. Whew, I thought I was going to be brief, but that's a lot of important stuff. I want to make sure that we went over very carefully. So I'll turn it back over to you, Madam Chair, for any questions or comments.
No, but I did skip over the approval of the December 5th minutes. I need a motion to approve.
So move.
Second.
Any discussion regarding those minutes? All in favor? Aye. Thank you. I also wanted to amend the executive session at Mr. McCall's request. He'd like to discuss an employee matter.
Is that not the one?
Can we need some measure of specificity beyond that. Amending the agenda, of course, is fine.
A potential conflict of interest issue.
Okay, regarding an employee.
Mhm.
So if we could just have a motion to amend the agenda to include an extra executive session item regarding an employment matter and a potential economic conflict of interest. You could just do it as I stated it. Have a first, a second discussion, and you need a supermajority. So you need 4.
Make a motion.
Any discussion? Any objections? All in favor?
Hang
I'm sorry.
on. Would this normally be would this normally be discussed with you prior to us getting that,
I
or?
believe it was.
Okay,
It is what I think it is.
Mhm.
Okay. Yes, sir, it is.
okay, that's, okay.
Okay, all in favor?
Aye.
Opposed? Okay, it's amended. Okay, so our first public hearing, ordinance 2017-28, an ordinance authorizing the execution and delivery of a ground lease agreement between Oconee County and the Foothills Farmstead. We had one person sign up to speak on this public hearing, and that's Ms. Sandra Gray.
Good evening.
Good evening.
First, as the owner of a small farm and a producer in Oconee County, I'd like to thank you all for all the support that you actually show agriculture in Oconee County. And I think there are great things to come in Oconee County in agriculture. So along that line, when I was reading the paper this morning and I saw that there was going to be the vote on this awesome new Foothills Farmstead replica farmstead, it says of the old days with old buildings, et cetera. So you're going to vote on the lease, and I began to look for the lease, and I couldn't find it. I don't know if it's available to the public for this property.
We can issue you a copy.
You can issue a copy, okay. I was just going to suggest that if it wasn't available, that perhaps you consider delaying that vote until we were, public was able to see the lease. But it is available. Okay, thank you very much. Okay.
Thank you. Would anybody else care to comment on this topic? Any written comments to our clerk, please? And with that, I'll close the public hearing for ordinance 2017-28. Ordinance 2017-29, authorizing Oconee County, South Carolina to enter into an equipment acquisition and use agreement for the purpose of acquiring certain equipment. This is for the rock quarry, and the amount not to exceed $6.5 million and change. No one has signed up for this particular public hearing. If anybody would like to speak now, you're welcome. Any written comments to our clerk? With that, I'll close ordinance 2017-29. Ordinance 2017-30, an ordinance authorizing the execution and delivery of an amendment to the fee agreement between Oconee County and ITEC. Again, no one has signed up for that public hearing. Anybody wish to comment at this point in time? Written comments to our clerk, please. And so I will close the public hearing on 2017-30. 2017-31, an ordinance amending Chapter 38 of the Oconee County Code of Ordinances regarding language in the multifamily housing issue. No one has signed up for that particular public hearing. Anybody wish to comment at this point? Written comments to our clerk, please, and with that, I'll close 2017-31. Okay, so third reading of 2017-28.
Make a motion to approve.
Any discussion?
Madam Chair,
Yes.
we're talking about ordinance 2017-28, correct? I was just trying to
That's correct.
confirm that that was, I just looked online, and I don't see it
Backup
in the
material?
backup material unless it's in the usually it's in order, and I didn't see it at the beginning.
I did not see it either. I think you all, in y'all's backup material, it's there. And I asked Katie to get it on, and we had the party today, and she didn't get it up to the thing, not her fault.
No.
But it's not in the backup material. By FOIA requirements, it doesn't have to be in the backup material until it's executed. But I have a copy I'm glad to give to
Ms. Gray?
the man back there so she can take a look at it.
You know, I hate to delay it, but if the public didn't have it available to them, you know, could we push this back to maybe later on in the meeting? I would make a motion to postpone it to later on in the meeting, to amend the agenda so that Ms. Gray could have the opportunity to review it. And
You wouldn't have to make a motion to amend the agenda. You could just make a motion to postpone to a time certain, being after some particular event.
Okay. I would make a motion to postpone until,
So right before the executive session, perhaps?
say, right before the executive session, yeah.
Okay.
So after committee reports. Second.
Any discussion? All in favor?
Aye.
Okay.
Did anybody else want a copy out there? Okay.
Okay, so 2017-28 we'll put on hold. Okay, ordinance 2017-29.
Motion to approve.
Second.
Any discussion? This is the funds for the rock quarry. All in favor? Aye.
Aye, sorry.
Opposed? Okay.
Well,
2017-30, the fee agreement between Oconee County and ITEC.
Motion to approve.
Second.
Any discussion? All in favor? Aye. Opposed? 2017-31, the language for multifamily housing.
So moved.
Second.
Any discussion? All in favor? Aye. Opposed? No second readings today. We have first reading of ordinance 2017-32, authorizing the execution and delivery of a residential lease agreement between Oconee County as lessor and Ken Crooks as lessee. Motion to approve?
So moved.
Second.
Any discussion? All in favor?
Aye.
Opposed? Ordinance 2017-33, an ordinance amending Chapter 38 of the Oconee County Code of Ordinances. This is in regards to the lake overlay.
Make a motion.
Second.
Any discussion?
Madam Chair, if you'd like. I just wanted to address, if you want me to, Mr. Markovich's comments about the penalty section. This is the very last paragraph in the ordinance, the attachment to the ordinance that you all have. It notes a violation of the article is punishable by a fine or imprisonment up to the jurisdictional limits of the magistrate's court. One. Additionally, it notes building and zoning permits may be revoked. This is the issue that Mr. Markovich spoke to. Stop work orders issued and civil fines levied. Those are statutory. Two are building code authored penalties. One's a statutorily authored penalty within the South Carolina Code. And then it says further the provisions and proscriptions and penalties within the International Property Maintenance Code may come into play, and that's separate. So they're IPMC penalties are not necessarily tied to the revocation of a building permit. So that was one issue he addressed. Revocation is something that's within the building official's rubric of things that he can do. Whether we had it here necessarily or not, it doesn't mean that he cannot do it because it's a building code authored thing that he can do. I would not want it taken out of there because it gives the public notice of what he can do under certain circumstances. I do not believe that that is at all the first resort because, as Mr. Markovich noted, it can be a substantial cost to get it done. Usually it's talking to the folks, then perhaps a stop work order and working the issue out. But it puts the public on notice of what can happen if they, refuse to abide by our ordinance and ignore a problem. So that's why the revocation is in there, make it clear.
Okay. Any other discussion?
Madam Chair, will there be a public discussion at third reading?
I'm sorry, Mr. Tretzky, come on up front.
Yeah, there always is, first, second, and there has to be a public hearing for every third reading.
Okay, Ben Turetsky, folks, that was the only,
This is not the approach, this is a business matter that's been brought to the table for council consideration. This is not public comment
Right.
time. I just want to make you aware of
Thank
that.
I'm not going to comment. I just asked the question. There will be one at third reading. Thank you.
Okay, I'm sorry, what was the question? What was his question?
He was asking if there was gonna be a public hearing, which there always is for a third
Oh, yeah,
hearing.
there's three readings and a public hearing. Absolutely. Mhm. Okay, so where were we?
Call for a vote.
Okay. All in favor?
Aye.
Aye.
Opposed? Okay. Ordinance 2017-34, an ordinance authorizing the execution and delivery of an extension agreement between Oconee County and Project Bremen.
Make a motion to approve.
Second.
Any discussion?
I'd just like to thank them for their continued investment and moving forward. I've heard very good things about this project, so I'm glad to see them succeeding.
All in favor? Aye. Opposed? Resolution, first and final reading for Resolution 2017-13, a resolution in support of the issuance by the South Carolina Jobs Economic Development Authority of its hospital revenue bonds, et cetera, et cetera.
Madam Chair?
Yes.
As this motion was tabled, or this resolution was tabled during our last meeting, we'll need a motion to recall it. This is a different procedure, so a motion
Okay,
to recall.
so I need a motion to recall.
Make a motion to recall Resolution 2017-13.
So we vote on the recall?
Yes, ma'am.
Okay, all in favor, any discussion? All in favor of the recall motion?
Aye.
Aye.
Now it is in front of you just as it had been seconded already, so it's in front of you for discussion.
Okay, so any discussion on 2017?
Make a motion to approve Resolution 2017-13.
Didn't need to, it's already.
He just said
Okay.
we didn't need
All
that.
right, sorry.
We're good.
Double up.
Okay. Any discussion? No discussion on this? Okay, I'd like to say a few words. First, I would like to comment on my previous request at our meeting on Thursday with Mr. Hunter Combe, Ms. Jean Ward, and Mr. Joe Blake. I brought up the issue of the inadequate response times in the north end of the county for EMS. And I had also mentioned that day that I was waiting to hear back from them to see if there was going to be any improvement in that situation. So I do want to thank Mr. Hunter Combe for calling me around 2 o'clock today to say, yes, there will be improvements. He sent me an email outlining the process that they're going to go through to try and help and improve the availability of EMS and the response time in the north end of the county. It will take a while to get it all in progress, but I'm glad that it's finally moving in the proper direction. So I would like to thank him for that. As far as the bonds go, I'm still very uncomfortable with the idea of this consolidation of debt. I would like to see Greenville Hospital succeed on their own and help us out as much as they can. OMH is a huge resource here, and we support them, and we support everything they do, and we support all our healthcare providers. But taking on extra debt from a different area of South Carolina just doesn't seem to agree with me a whole lot. So on that note, unless there are any other comments, all in favor of Resolution 2017-13? All opposed?
Aye.
No. All right. Moving on, discussion regarding action items. Letter of support for JAG Court System Efficiency Grant Application. What do we need to do for this?
I would just make a motion to approve the letter of support in its form as included in the backup material and authorizing you to sign on behalf of County Council.
Okay.
Fair enough?
So moved.
Second.
Any discussion?
Mr. Moore, what does JAG stand for? I thought it's Judge Advocate General.
No, hang on. Hang on.
That's military.
Justice, I can't remember. Justice Assistance Grant. Justice Assistance Grant.
Not to be confused with the UCMJ. Okay.
Nope.
Any other questions or comments? What was the total grant for? What was the amount?
$22,000. Is what, well, no, I'm sorry, that's what we have spent. In my notes, I had that wrong number. You know, I don't have that in my notes.
Was that our portion?
I want to say it's 125,000, but I may be confusing that one with the other one that's going to come before you at the next meeting.
I think
Okay.
it was right.
Yeah, I think
And then our part was 22,000.
22,000, right? So I think it's right around 125,000 and change, if you will, give or take.
Okay, because there's two grants, one for the courthouse and one for the sheriff.
That's
And the
correct.
sheriff is the one coming up in January.
That is correct.
Okay, I was mixing those two up. Okay. I know. All in favor? Aye. Opposed? Passive landfill gas vent trench for solid waste, $132,211.
Motion to approve.
Second.
Any discussion? All in favor?
Aye.
Review and approve the subleases between the Fair Oak Youth Center, Inc. and Lifeline Community Church, the Fair Oak Youth Center, Inc., and Hyatt Landworks.
Motion to approve.
Second.
Any discussion? Mr. Root, were there any reservations about having Hyatt Landworks there?
It's a landscaping company.
Uh-huh.
That's my research on it. I asked Mr. Adams that question, if it's something different than what I found. He didn't respond, so I'm assuming it is what it is on his Facebook page, which is a landscaping company. I have a reservation because that's not outwardly something that is for a public purpose and community enrichment. But if I were their attorney, which I'm not, but if I were, I would argue that this is a small portion of the facility that's being leased to generate some income to support their El Masonori nonprofit enterprise. So I think that's what Mr. Adams would argue. If it were a substantial portion, a bigger portion.
It's just one little room in the back, from what I've
That's my
seen.
understanding. It's
Mhm.
it's an administrative office for them.
Yeah,
for
mhm.
A small portion. So this is a good reason why to bring them in front of you so you can analyze it. That would be, speaking for him, which I don't feel comfortable doing, that would be what I would
Mhm.
probably say is why it's for a public purpose, because it infuses the nonprofit with some money, which they're using for, it's a big school and it takes some money to operate.
Mhm. Okay.
And if the landscaper was willing to assist in some ways when they have needs on the grounds, that may help as well, because he's providing, support and work to benefit the Fair Youth Center.
Is that the case?
I don't know.
Oh.
I'm saying if he would be willing, that would make it even more
Attractive.
Mhm.
valid, if you will.
Oh, we'll talk to him. He's a good guy.
Yep.
Mhm. Any other discussion on this?
While we have it on the floor, I know Mr. Adams wanted to reconfigure this mechanism so it could be more quick.
Mhm.
If y'all want to give us that instruction, then it'd be great. Otherwise, what I would like to have happen is to continue that before the leases are signed, subleases are signed, you give them to Mr. Mulder so he can analyze as a first tier whether this is consistent with permitted uses, whether this is a large sublease,
Mhm.
we have the insurance in place, and if he has any trouble with any of those issues, then he can bring it forward to council. May not need to come to council. Maybe we could do it quickly. It's very clear, like the Boy Scout lease, I would say.
Mhm.
Madam Chair, I think there was just a little confusion on there. He's trying to hurry up and get it leased and do the things that he was planning on, because as he states, there's a lot of projects that people have kind of sat by when they had opportunities, and that's over his, tenure here. And he wanted to make sure with this opportunity to move forward with that as quickly as possible. And as I advised him, the quickest way possible is as soon as we know, and everything ends out falling into place properly. And that's not just with this lease, because hopefully there'll be other leases that come up from other projects and everything that we have going on that will follow the same thing as this. And so, with the new projects such as this, it's important that we kind of map those details out and have an understanding on his side as well as our side. And I think I like how things are going now. It's just a little bit of misunderstanding that as soon as this comes up, hey, this guy wants to lease it, here's what it looks like. If you get the approval, even during openly talk and communications, at least we know how to proceed properly. So I'm fine with how they are. And I do appreciate the communication back and forth with them as we all learn this, new vendetta. And I appreciate all that they're doing up there. The amount of people and movement that they've got going on in that place is great. So it's been a very good decision by the county to take on that building and that project, so.
Anybody else? All in favor?
Aye.
Board and commission appointments?
I have a building codes on the line. It may be a breakfast or something to get him to sign the paper, but, so we are going to meet tomorrow to talk about it. And he has a lot of building experience as he does that for a living. So, and I know as most of your builders on there was a little bit of talk about if I'm a builder, how can I be on building codes? And the only thing from my knowledge is he would, if it was something him or a direct connection to him, he would have just abstained from it, and that would be it. Because obviously we want people with building codes experience on the Building Codes Appeal Board. So hopefully in the first of the year, we will have that filled.
I won't hold my breath.
2 breakfasts. I'll just keep, maybe it'll be a monthly breakfast, I don't know if we.
All right. Any unfinished business?
Yeah, because it's a little hot topic right now. On the courthouse air system that we were talking about, can you give a little quick update on that from our side?
Yes, sir. We actually have reached out to the mechanical engineer through our architect that we have on call to look at the design of those. We're seeking bids right now and looking for qualified companies to come in and provide a quote. As we said, it's going to be troublesome for a little while longer, but unfortunately, we've got to go through these steps in order to get it designed correctly and procure it under guidelines. I don't know if you have any further other than that.
I just wanted to,
While the architect was looking at the detention center of the sheriff's department upgrades, we had him immediately go over and take a look at that as well. So they're working on it, and we just asked them to please bear with us. We know it's unbearable in there.
yeah, and it has passed council. We're just in the procurement side of things, so as long as that comes up, I just kind of wanted to, the wintry end is near, so.
Obviously, it still requires your approval to approve the bid itself. but
correct.
We're getting there.
Right. I say wintry, it depends on which side and which room you're in. Summer, there's no spring there. We either have winter or summer. There's no spring there, so 2 seasons. So I appreciate your work in that, and I know we're moving forward with that. Thank you, Madam Chair.
Any new business? There are no council committee reports tonight. So we're back to 2017-28.
We need a motion to bring that back up.
You do not. It drops out of the sky right now, essentially right in front of you, as it was when the motion to postpone was made. And I don't recall if there was a first and a second, or if the motion to postpone came first.
There was
It was brought up, and then I made the motion to
First and
postpone.
second, and then a motion, so now it's in front of you for discussion.
Okay, any discussion on 2017-28?
Madam Chair, being that Ms. Gray was the one that requested to see a copy of the lease, and I don't know how we procedurally would do this, but would be to ask her if she does have comments on that now that she's had an opportunity to look at it, and I don't know if this was enough time for her to review it or not, but, I mean, that's the whole point of the hearing is so people can make comments on it.
Not typically allowed for public comment during the business portion when it's on the floor, but.
Right, I know. But we had a public hearing without actually having the document, and I
No,
don't
that's fine,
fault,
that's
we
fine.
had a great staff Christmas party before that, so I don't fault our clerk at all. Or
Ms.
Ms.
Gray, did you get a chance to glance over the lease?
I have. It's a little detailed, so it takes a while, but I have no question.
Okay, thank you very much. Okay. Where are we?
call for a vote.
2017-28, call for a vote. All in favor?
Aye.
Opposed? Okay.
Thank you, Mr. Kane, for pointing that out, though. No, that's good. No, that's good. We got to make sure Mr. Root and Ms. Smith over there are staying up to date.
I need a motion to recess for executive session. Number one, to receive legal advice and discuss a contractual matter related to the Oconee Joint Regional Sewer Authority and operation of the Golden Corner Commerce Park Pump Station and associated infrastructure. Number two, to discuss employment matter related to evaluations and related forms. And number three, to discuss an employment matter and a potential conflict of interest.
So moved. And thank y'all for coming. Merry Christmas. I know some of y'all don't stay for after executive session, but we really appreciate those that continue to come.
That's right. This is our last meeting of the month, so Happy New Year.
So we got a second.
Do we have a second?
Mr. Convene.
Second.
All in favor?
Aye.
No action was taken in executive session. No actions are needed. Do I hear a motion to adjourn?
Merry Christmas. Adjourn.
Merry Christmas, everybody. Happy New Year.